permit me to introduce to this panel one of the speakers of this session. Remember that this session is Efficient Justice Delivery, a review of the outcomes of the Justice Sector Summit. And to discuss this very important topic is my Lord Honorable Justice Eneche Eleojo of the Federal Capital Territory Judiciary. You are welcome, my Lord. Also, we have a very senior lawyer, my former boss, still my boss, a very learned senior advocate of Nigeria to discuss this very important topic. Ladies and gentlemen, please join me in welcoming Mrs. Funke Adekoya, senior advocate of Nigeria. Those who know her and those who do not know her, please be informed that she's very passionate about reforms in our judiciary as well. She wants us to move from the ordinary to the extraordinary. And last but not the least, permit me to welcome Mr. Akitayo Iwilade, representing Mr. Dakpo Akioshun, Senior Advocate of Nigeria. He has some very interesting points to give to us this afternoon on efficient justice delivery, and we look forward to hearing from you, sir. Thank you very much. Please, a round of applause for him. You're welcome, sir. I'll now hand you over to the able hands of our moderator, Dr. Tunde Ajibade, Senior Advocate of Nigeria. Thank you, sir. Mr. Moderator.
Good afternoon, distinguished ladies and gentlemen, distinguished colleagues, and welcome to this session. As Mr. Emunjeze, our able coordinator, said, this is a very, even if we say so ourselves, very important session dealing with justice sector reforms and dealing with the outcome of one of the significant achievements of the outgoing NBA administration. My name is Babatunde Ajibade, and I was the chair of the NBA's Judiciary Committee for the 2022 tenure of the NBA. And one of the things that the NBA president mandated the Judiciary Committee to do during our tenure was to hold a justice sector summit. And this session, that summit held in January, on the 25th of January this year. And this session is basically to report back to you, for those who were not able to attend or to follow the proceedings, to report back to you what we sought to achieve and also what we're doing about the outcome of the summit. The panel has been introduced to you already. To my immediate right, Honorable Justice Zana, CJ of Borno State, and to my immediate left, Mrs. Funke Adekoya, SAN, were both panelists at the summit. So they're very well positioned and well situated to assist in discussing what the summit sought to achieve and what has been happening since then. Justice Enenche also, even though he was not at the summit, has been following what has been happening. And Mr. Ewilade, who is representing Mr. Dakpo Akioshun SAN, has also been following the development since the summit. And the way we intend to run this session, we have 90 minutes. I'm going to give a brief as I can make it, summary of what the thinking was behind the summit and what steps we have taken since then. And then I'm going to isolate some of the key issues which each of our panelists are going to address, with an opportunity for the other panelists to also comment. And we hope to be able to leave at least 20-25 minutes at the end for Q&A so we can get your feedback. So just to give you the background, one of the things that I think we did differently with this summit was to try to ensure that we brought all the stakeholders that are engaged in the justice sector together. As Mrs. Adekoya was quick to remind me when we were discussing earlier, the NBA has been having summits. We've had summits and summits and summits, and yet the problems don't seem to have gone away. And one of the things we thought we could do to address that concern was that rather than the NBA, the lawyers just sitting together and discussing what we think are the problems of the justice sector, that we should get all the stakeholders who have the ability to influence justice sector reform to get them into the same room. So this summit was not a summit of lawyers. The summit was co-organized, not just by the NBA, but the NBA, the NJC, the Justice Reform Project, the UNODC, the Konrad Adenauer Foundation, and most importantly, or equally important, the Justice Research Institute, which is an NGO that has also put a lot of effort into justice sector reform over the years, and which is chaired by His Excellency, the Vice President of Nigeria, Professor Yemi Osinbajo, SAN. And using that as a basis, we made sure that we invited all the necessary stakeholders to attend that summit, and we did everything possible to get them there. So you had representation from the NJC, the CJN was there, ably represented by Honorable Justice Inyang Okoro. The Honorable Attorney General of the Federation was there. His Excellency the Vice President was there. The Chairman of the House Committee on the Judiciary, Honorable Onofiok Luke, was there. The DG, the Director General of the Budget Office of the Federation, Mr. Akabweze, was there. All the chief judges of the 36 states, all the attorneys general of the 36 states, all the grand caddies, all the heads of court, the Federal High Court, the President of the Court of Appeal, they were all invited because we wanted every stakeholder to be present, because we realized that to make the changes that we're seeking to have in the justice sector, it would not work if all the stakeholders were not in the room. The second thing was, even before the summit, we had set out deliberately to say that this was not going to be just another talk shop. It wasn't going to be a summit to talk about the problems. We all know that there are problems in our justice sector. We know that cases take too long. We know that there are challenges with funding for the judiciary. We know that there's a problem with appointments to the judiciary. But we weren't going to just come there to talk about problems. We were going to go deliberately to come away with solutions. And not only solutions, but solutions that we would then follow up to implement. So we went through that summit. We came up with a communiqué, which was widely circulated. And we set up an implementation committee, which has been meeting regularly since then. Also, we set out deliberately to say that this summit would, God willing, be a periodic event. In other words, it wasn't going to be just a one-off, but it would be an event that will be conducted or carried out at regular intervals. If I had my way, what we propose is annually, but of course, that is for if it's convenient for all the stakeholders. We think that if we do it periodically, it will enable us to monitor progress on the problems that have been identified, the solutions that have been proffered, and how those solutions are being implemented. Now, we also were aware that we could not address all the problems in the justice sector in a one-day summit. And therefore, we focused on three critical, what we consider to be the three most critical challenges facing the justice sector. And these areas, we believe, are interconnected. We took quite a bit of time in developing the concept note. And we started with the question of appointments. We think that there is a general dissatisfaction with the process for judicial appointments in Nigeria. And this has a knock-on effect. It has a knock-on effect for the perception and the confidence that even the profession, talk less of larger society, has in our justice sector. If the profession itself does not feel confident that it is the right members of the profession that are being appointed to the to the important position of adjudication, then there is no confidence in our justice sector. And of course, this filters down to the larger society. We thought that the process for judicial appointment was too opaque. You had too many instances in which you would hear announcements about XYZ has been appointed a judge, and it is only afterwards that you would have members of the profession wondering, how did this person become a judge? We know him or we know her. This person does not, qualify to be a judge. But it was because the process was not transparent. And once a judge is appointed, as we all know, it is extremely difficult to remove the person after the event, no matter how inappropriate the appointment may have been. The second thing that we thought was important to address was the question of funding. The funding for the judiciary and the administration of the courts, which are two interrelated issues, and which also relate to the first, and I will establish the connection shortly. And then the third area that we thought we should address is the big elephant in the room, which is the inefficiency of our court process and the length of time that it takes for matters to go through our courts. Indeed, one of the statements that we made in the concept note, which I found quite interesting, which was a quote from His Excellency the Vice President, that unlike in other countries, the problem in Nigeria is not access to justice. The problem is exit from justice. You can get in very easily, but getting out could be quite problematic. It could take you 10, 15 years to resolve a simple contract dispute. So these were the three areas that the summit dwelt on. And we came up with robust recommendations. Some of those recommendations are already being implemented. Some of them are less easy to implement, and we were realistic in our expectations that there was no way a one-day summit was going to come up with solutions that would solve these problems immediately. We realized that it is going to be a marathon, but that with deliberate and conscientious effort, we can overcome these challenges and make our justice sector what we would all like to see it be. So, taking the question of judicial appointments, Mr. Iwilade is going to speak to the issues, but I can just briefly identify what the key issues were that came out from the resolution of the summit. The first was that methods needed to be adopted and steps taken to increase the level of transparency in judicial appointments. I think I've already foreshadowed that in what I've said. And I must say that, as you may have noticed, the NBA Judiciary Committee in the last dispensation has already started walking that talk. One of the things we did was that every time we received a notification from the courts indicating that judicial appointments were about to be made and requesting that the NBA should forward recommendations, we made sure that that process was transparent. Historically, the NBA has always been involved in judicial appointments, but the process by which those appointments were made was not put out to the profession. One of the things we did immediately was to start implementing what we're talking about, and I'm sure you would all have received notifications in relation to the ongoing appointments to the Federal High Court, the ongoing appointments to the Supreme Court. Whether that intervention is sufficient is for us to follow through on, but at least we have started implementing the transparency initiative. The second was putting in place methods to ensure that the appointments to the courts are based as best as possible solely on merit and not on political or judicial influence. Because we think that clearly a lot of the judicial appointments that we have seen, not all, because we do have some first-class judges, as we all know, in our justice sector, but we also are aware that there's a perception, and I believe that perception is 9/10 of reality, that quite a lot of judicial appointments arise as a result of connections and not because the appointees are deserving. The third which is also related to quality and criteria, is that aside from initial appointments, elevations from one level of court to the other should also be based on identifiable criteria. You shouldn't have a situation in which a high court judge goes to the Court of Appeal and there's no basis on which you can establish or understand why it was Judge Justice A rather than Justice B that was elevated. And ditto from the Court of Appeal to the Supreme Court, to the extent that those appointments are only from the pool of existing justices. In relation to budgeting and funding for the judiciary, we thought that steps should be taken to establish clarity as to which tier of government is responsible for funding the judiciary. There is a significant lack of clarity in our current constitutional arrangements on this issue. We also thought that there should be greater transparency in relation to the planning and budgeting for the judiciary. And Honorable Justice Enenche is going to address this in a bit more detail. Also, that the funds allocated to the judiciary, that there should be more clarity as to how those funds are prioritized in the judiciary's budgeting. And lastly, that we should ensure that the administration of the courts is handled a lot more efficiently than we see at present. And my Lord Honorable Justice Zana is going to speak to this. The last area is with the issue of delay, and Mrs. Funke Adekoya is going to speak to this. This is a multifaceted problem. We know that the delays in the system are not attributable to just any one cause. There's a combination of factors. Some of the factors are, as I said, all these factors are connected, and if I could just connect the dots now, if you have judges who are not of the right quality being appointed, obviously their capacity to deal with cases efficiently is compromised right from the get-go. So that will result in delay. If you have inadequate funding for the judiciary, then the ability of the judiciary to even attract the right kind of talent from the bar, the ability of the judiciary to attract senior advocates to go to the bar, to go to the bench, is much limited because they would look at their current earning capacity as practicing lawyers and consider why should they take such a massive drop in income just because they want to go and serve the country. So obviously there's a connection between the appointments, the funding, the administration, and the delays that we're seeing in the system. So that is what the Justice Sector Summit sought to achieve. And having set out this background, and I hope I haven't taken up too much time, I will now call on Mr. Iwilade to share his thoughts in relation to the appointments system and the recommendations that were made by the summit and how they are being implemented. And of course, other members of the panel will also chip in. Mr. Iwilade, you have 8 minutes, and I'll be timing you strictly.
Thank you very much, Leonard, Senior Advocate. And I must also thank you for allowing me to be seated with this very distinguished panel. I think it syncs with the bold transition theme of this conference. So, and also thanks to the distinguished audience that are here to listen to our thoughts. So, I share the thoughts as expressed and as often discussed with the person I am representing on the panel, which is Mr. Dapo Akioshu, Senior Advocate of Nigeria, and the Managing Partner of Simmons Cooper Partners. Now, of the 7 recommendations you mentioned, Leonard Senior Advocate, for the purpose of time, I would concentrate on just about 2 of them. The first one is the question of the opacity in the appointment process of judicial officers. And without necessarily rehashing the problem, I think that we should even be ashamed as a profession that a set of people that will literally grant the power of life and death over citizens of our country people whose determinations, whose erudition, whose integrity, character, and just all of philosophy of life can impact on whether this country bonds or survives. There's absolutely no basis to have the appointment process of such persons shrouded in any kind of secrecy. So I think we should be ashamed of that as a profession. And one must commend the communiqué that came out of the Justice Sector Reform Summit, which identified that. Now the question is that how far have we then gone from January till today in implementing and opening up that space to a more transparent process? Thankfully, I saw the information you passed across by your good self, sometimes earlier in the year. But the question is that how has the judiciary been receptive of that effort to attempt to publish the names of people who want to aspire to the bench, to provide their requisite qualifications and all of those things? I don't think we've seen much of that synergy yet. Also, I'm happy that I was present at the plenary session I held in the morning, where the learned senior advocate, Mr. Okpoko, SAN, also mentioned that one of the recommendations that was made to allow for credible, known members of the legal profession who are outside of the bench to have the opportunity to sit in appellate courts, that itself, in spite of the best effort of the Nigerian Bar Association to make those recommendations to the judicial authorities, by the time the names and the list came forth, there was not one single person that was deemed fit to sit on the appellate bench within that process. So what that shows is that there appears to be so much conversation about these things, but the commitment and the conviction to make these things actually work for the benefit of the society is really, really still below par. And I hope that these sort of conversations can lead us into much more efficient ways to get at that. But also talking about the question of elevation, so that I don't exceed the timing that my learned senior advocate has given me. Also talking about the elevation, a part of it that matters, that I think should matter to us, is where there was a provision that says that elevation from a state strata of the court to an upper level should be dependent on some objective criteria. And one of those criteria is the quality of judgments. I'm very, very particular about that. And then, so when we say quality of judgments, exactly what do we mean? Do we mean judgments that resolve the substantive questions that are actually taken before the courts, or judgments that merely resolve procedural and technical issues? I think that if we would tell ourselves the truth, and this is not just the problem of the judiciary, it is the problem of all of us, perhaps all of us seated in this, or maybe with the exception of those of you on the high table here. Now, we will find that if we look through the entire structure of our law reports today, virtually 70 to 80% of decisions that are being made, they are decisions on procedural issues. And that is something that we should be concerned about as a profession. Because if indeed we say we are serving the society, and all we do are the theatrics and the histrionics of procedural issues in court, to the extent that the real issues that everyday members of society bring before our courts for adjudication hardly ever gets resolved, I think that's a major problem. So one of the ways to incentivize this process of elevation is to make it as part of the rules that judgments that would be submitted for assessment for quality and elevation from one lower court to the higher court must be judgments that were determined on the merits, not judgments that are determined on technical issues, procedures, and all of that. But of course, in dealing with this, it is not just the problem of the judiciary. It is also a responsibility of us as lawyers. But we need to empower the judicial officers. For example, the rules of court. We need to ensure that the rules of court provide far more discretionary powers to judicial officers to be able to do justice and even depart from those rules where the ends of justice so demand. For example, we have seen it with even statutory provisions. If we need to look into some of our substantive laws, including the Evidence Act, where some of the irrelevant provisions in the Evidence Act can also be retweaked, amended, to grant more discretionary powers to the judges to be able to focus strictly on the substance of issues before them. And very lastly, because I don't want to fall on your hammer, legislative advocate, I just want to make one point that I want us to ruminate about as a profession. I recently had the opportunity to look through the Legal Practitioner Disciplinary Committee's rules. And in that rule, I found that there are two provisions that should strike us in that rule. One of it expressly talked about dispensing of application or compliance with the rules, one of the rules. Another one also mitigated, in fact, watered down the application of the Evidence Act where it would amount to an injustice or where it would not aid the purpose for which proceedings is going on. Now, that's a proceedings where both the defendants, the defendants often lawyers, the panel sitting are often lawyers. But because we understand that sometimes a slavish application of rules, slavish application of the Evidence Act oftentimes obscures the ends of justice. We have lawyers, as lawyers, because we take the issue of discipline quite seriously in the profession, we have decided that we should dispense with those rules where it will not aid the cause of justice. But conversely, for the lay people that we serve in society, we have now created rules which are the slightest error made by their own legal practitioner, errors made by us. We end up punishing the litigants. We find ourselves dismissing cases. We find ourselves striking out cases. We find cases like Inweke and Okafor that should never have found its way into our jurisprudence. We need to think about all of these things. And I need to save myself from your hammer. Let us advocates. Thank you.
Thank you so much, Mr. Iwilade. Thank you so much. Thank you for those very, very important points. Indeed, I think towards the end there, what you were saying reminds me of a joke I heard once about a gentleman who got into a cab in London and asked the taxi driver to take him to the High Court of Justice. And the cab driver said, I can take you to the High Court, but I don't know about justice. I don't know whether they do any justice there, but I'll take you to the High Court. So, and that is the perception of the layman when they hear some of the technical jargon that goes on in our courts. When they hear about the fact that a case that has gone on for 12 years is thrown out on appeal because the process was signed by John Bull and Co. rather than Mr. John Bull, even though Mr. John Bull is alive and he has not denied that he issued that process. But 12 years of litigation is wiped out completely just on a technicality. Those are the kind of things that make people on the street wonder whether the high courts are just courts or whether they're courts of justice. Mrs. Adekoya, before, I think on this issue of judicial appointments, we should do the bar before we do the bench. So what are your thoughts on this question? You have just 2 minutes.
On the issue of judicial appointments, I believe that the summit has not yet achieved its objective. The objective of the summit was to ensure that judicial appointments brought credible personalities to the bench and allowed for a system where elevation was not the norm, rising from the High Court to the Court of Appeal to the Supreme Court. In terms of elevation through the ranks, I believe that the advocacy of the Bar Association so far has fallen on deaf ears. We have not succeeded. In terms of more transparency in how judges are appointed, I would score the summit 50%. 50% because the state NJCs, JSCs contact the bar to say we want to appoint this number of persons, can you give us feedback? But it is more transparent to become a senior advocate of Nigeria than to become a judge. When you are shortlisted for being a senior advocate, your name is published in the newspapers, and the public are asked to comment if they have anything to say as to your suitability for elevation. And I do not see why that should not be the same standard for judges. That's the first point. The second point I would like to make is that the qualifications for becoming a senior advocate are more onerous and more rigorous than becoming a high court judge. We have seen 2 senior advocates who have since decided to take up judicial appointment at the high court level. And I would wish that perhaps there is more advocacy to support more senior advocates who so desire, after attaining the rank of senior advocates, to go to the high court bench and enrich the high court with their experience, hoping that we still have that battle to fight to open the senior levels of the judiciary to non-judicial officers.
Thank you so much, Mr. Adekoya. Indeed, one of the caps I wear is as a member, although on my way out now, of the Legal Practitioners Privileges Committee. And one of the recommendations that I believe that if I had my way, I would insist, is that one of the conditions for becoming a senior advocate of Nigeria should be that you indicate a willingness to, even if not on a full-time basis, to contribute some effort and time to acting as a part-time judge to help to decongest the courts, even if it's just to take applications, so that the judges, the full-time judges, can concentrate on the substantive matters. That would be one of my recommendations, which I agree entirely with Mrs. Adekoya, that we must make the senior advocates do a bit more than just make more money. My Lord, Honorable Justice Zana, your thoughts on the issue of judicial appointments. I know that you are on the NJC. I know that you are aware that post the summit, and probably even prior to the summit, there was already some movement within the NJC to enhance the judicial appointments process. Are you able to share any thoughts as to where that process is at and whether the Justice Sector Summit has given it any added impetus?
I think this is going to be the most difficult thing for me to comment on. For so many reasons, I can almost feel some people smiling to themselves. But fact is, the point has already been made that subsequent to the resolution of the summit, some appointments were made and nominations were made, and it's obvious from there that whether those recommendations have been taken into consideration or not, it's obvious. However, it's a continuous thing. We have members and issues are coming up in the council, and it's a continuous review going on of all aspects. And I would not advise anyone to conclude that it's been jettisoned. I have limitations, obviously, on how far I can talk on some live issues. So all I will say is, all hope is not lost.
Thank you very much, my Lord. Justice Enenche, did you indicate that you would like to recuse yourself on this particular issue, or would you like to comment?
Thank you very much, Leonard Silk. Well, like the Leonard Silk knows, for some personal reasons, I would not ordinarily speak on this issue. But I'll make general comments, beginning with the fact that we are not where we should be yet, but all hope is not lost. And I say this because I want to encourage the bar. The bar is a critical stakeholder in this project. And I must encourage the bar to take the appointment of judges more serious. I say this because I have had the privilege of working closely with 5 of the 6 chief judges in Abuja, and I know how this process works. It begins with the publication to the respective NBA branches, and also an online publication of the notice of appointment, both on the website of the High Court and on the website of the Judicial Service Committee of the FCT and of the states. But the question I ask is that how many petitions or how many remarks have we received as to the appointment of these persons? Most times you do not receive any, both from the bar and from the public. So what that tells me is that probably the members of the public and the bar as well are unfortunately not showing enough interest in their appointment. The only time you see interest is when we have summits and seminars like this, and everybody begins to speak. But once this ends, and we go back to our respective homes and offices, nobody shows any commitment again. I have never, in my public life of witnessing the appointment of judges, had any petition or any complaint against anybody who was recommended to be a judge. And if you ask me, it's not all hunky-dory about everybody who wants to be a judge. There must be some things. But if we do not see it, it means that certain people who should be showing interest and commitment to the process are not doing it. So I think the bar should actually do more.
Thank you so much, my Lord. Well, my Lord, you make an important point, and it's from a very interesting angle you have addressed this question, because I have had cause to complain also, or to express concern about the inadequate interest that the bar has shown in the judicial appointment process, but approaching it from a slightly different angle. My Lord's observation seems to be that there is the names of potential appointees is made known, but the bar or the general public do not show interest in complaining or identifying those that are not suitable. My own concern has been the reverse, which is that the bar has historically, and I must say, even though it will sound self-serving, that this current administration has tried to change that paradigm. But I think that the bar before now had dealt with this as one of the perks of being a bar leader, either at the national level or at branch level. Because as I said, if you look at the NJC's guidelines for judicial appointments, it makes clear that the NBA has a role to play. But yet we have had situations in which judicial appointments have been made in which clearly the NBA at some level was involved, but the profession or society was not involved. And I think that the bar ought to have taken a more proactive stance in ensuring that there was a greater involvement. And I know that my Lord has a... Okay.
I just, out of a good conscience, have to make the point that this effort that you have said started, I think, I was privileged to have information during A.B. Mahmoud's tenure, when requests for nominations went to the NBA, unlike the previous practices whereby the nominations were just made by the bar. He constituted a committee of the NEC that sat down and went through a process and came up with the names, recommendations to be made. I happen to have known that. Just out of a clear conscience, I have to make that point.
Thank you so much, my Lord. So I mean, my Lord makes clear that this is not the first time that the bar has been proactive, but I think what we need to do, and this is speaking to you, my colleagues, is that we need to be consistently engaged with this process. It shouldn't be something that comes and goes depending on who the NBA president is. Okay, so that is it with judicial appointments. Moving on swiftly to the question of funding of the judiciary. I've already mentioned what we see or what the Justice Sector Summit saw as the challenges, the lack of clarity as to which tier of government is responsible for funding the judiciary, the lack of clarity as to the process by which the budgeting for the judiciary is done, and by which the judiciary is made to account for that which is made available, even if, as we all believe, it is inadequate. And I'm sure we're all aware of recent developments. When we were organizing the summit in the lead up to January, we were not aware of what was coming with the recent debacle at the Supreme Court, leading to the petition or the letter written by justices of the Supreme Court complaining about the management of the Supreme Court's funds. But I think recent developments, those developments have made this issue even more topical than they would have been. It's no longer just a matter of theory, that there is a legitimate concern about how the judiciary accounts for the funds that are made available to it, even if we believe those funds are inadequate. And one thing that is significant, and Justice Enenche is going to speak to this in more detail, but one thing that is significant is that at the Justice Sector Summit, the executive and the legislature were unanimous in their position and in their contention that the judiciary's management of the funds made available to it is opaque and that the judiciary does not open its books. But the judiciary has also consistently insisted that the books are open and that the executive, the Office of the Auditor General of the Federation, even has resident auditors sitting in the courts. So where we think that the bar, and not just the bar, but the rest of civil society has to get involved, is to get the executive and the judiciary to come together and sit around a table so that we analyze this issue. And that is one of the things that we're trying to address with the Justice Sector Summit Implementation Committee. So Justice Enenche, please, if you want to speak to this in a bit more detail.
Thank you, Leonard Silk, once again. Okay, now, like I said at the beginning, we are where we are, but I think we can have a better system. And in having a better system, I want us to understand that all we need to do is to insist that all institutions of government involved in the process of doing anything at all must be alive to their responsibilities. I say this because there is already a constitutional safeguard to ensure that the funds of all ministries, departments, agencies of government, including the courts, are properly managed. And I make a specific reference to Section 85, subsection 2 of the 1999 Constitution, which provides that the Office of the Auditor General shall audit all these accounts, including accounts of the courts, and make a report of that to the National Assembly. Now, what the Constitution seeks to do is to provide a sort of constitutional balance. So you have agencies, including the court, expending resources. Then you have a different arm of government ensuring that those resources are properly expended. Just like you said rightly, Leonard Silk, all federal courts have inbuilt auditors who monitor and control expenditures. You know, every single kobo, every penny that is spent by the court goes through an audit process. And at the end of that budget year, a report is made to the National Assembly. And the National Assembly has the statutory responsibility to go through this report and ensure that things are done properly. So, if we say that the accounts of the judiciary or any arm of government are that, is not open to scrutiny, then we should also throw the question back to the body or the agency that has the responsibility to look at this. So we must all sit together and determine where the problem is. Let us ensure that institutions of government that have responsibilities also perform their roles and duties under the Constitution. Now, as a follow-up on that, we all know that the Chief Judge is the judicial head and also the administrative head of the court, while the Chief Registrar, acting as a PAMSEC sort of, is the Chief Accounting Officer. Because the Chief Judge is the administrative and judicial head, he has a considerable say in the development and implementation and monitoring of the budget of the court, while the Chief Registrar is the Chief Accounting Officer. It is the Chief Registrar who understands how the monies are spent and to ensure that proper controls are put around the funds of the court. So bringing the two of them together, I have worked with 5 chief judges, like I said, and I have never seen any chief judge who had a say in what contracts are given out. But of course, the chief judge is interested in ensuring that the priorities that he has set for the administration are properly carried out under the budget. And that is where the work of the chief judge stops. So we need to be mindful that in as much as we say it's not good for the judiciary to give contracts and all that, the chief judge must be interested in what goes on in his courts, even though he does not award contracts personally, he does not know who the contractors are, and they have no contract with him everywhere. That one is the function of the chief registrar. So we must create that delicate balance so that in trying to perfect one system, we do not kill another one.
Thank you so much, Justice Enenche. I mean, this is where I think, obviously, things get a bit controversial, naturally. And this is why also, in putting together the Justice Sector Summit, we ensured that we have representatives from all stakeholders, because we would not necessarily always agree. And this is one area where there is disagreement. The position of the judiciary, as clearly stated by Justice Enenche, is that the regulation of the expenditure of judicial funds is sufficiently safeguarded by the fact that the Chief Judge is the Chief Administrative Officer or the head of court, and whilst the Chief Registrar is the Chief Accounting Officer, and that there is sufficient check and balance in that system to ensure that the funds of the judiciary are properly utilized and properly disbursed. I make no bones about saying that the perception from this side, I believe, is that those checks and balances are not working. If those checks and balances were working, we would not have had the kind of letter that was written by the justices of the Supreme Court accusing the CJN of mismanaging the funds. Because remember, that letter was not written to the Chief Registrar, it was written to the CJN. So that belies the perception that the Chief Registrar is the Chief Accounting Officer and the CJN or the head of court has nothing to do with it. There's clearly something more that needs to be done. And I will ask Justice Anna if he wants to comment on this. I think that the justice sector, this is one area in which we need to do a bit more work to tighten the process. And one aspect of it, which I discussed earlier, is not just about accounting for the money allocated, even the budgeting, even determining what are the priorities. We have situations where, you know, the judges, some judges are, with respect, you know, very, very comfortable in relative terms, whilst there are other aspects of the justice sector that are that are suffering. The magistracy, You even have some courts that don't have lights, they don't have roofs. But then, so there's a question as to how the budget for the judiciary is prioritized. And it seems to me that currently it is dependent on the aptitude and goodwill of the particular head of court. There isn't a system in place to ensure that these funds are expended for the benefit of the justice sector as a whole. If you have a good CJ, then you might find that the funds are being properly dispensed. But if you have a CJ whose priorities are different, my lord?
Another difficult one for me. But I never shy away from issues of reform. I must make it clear, one, that I'm not very sure I agree with your capturing of what you refer to as the recent letter written by justices. I'm not sure I will agree with the way you captured it, but it's not even relevant to my own position. My position, and actually the task you assigned to me is also dovetailing into that, is that we have a system in place and we can improve on it, and we should improve on it. Some are satisfied with the system as it is. Some are not satisfied. My position is that those who are satisfied with the system as is should not be satisfied. We should seek to improve it, and we can do it. I'll talk further when it's my turn to talk on that. That's my position.
Thank you very much, my lord. And I think this is an area where we speaking for the bar, this is an area where we think that injecting non-judicial input into the process is essential to achieving an optimal outcome. And I would ask Mrs. Adekoya to share her thoughts on this, because we have talked about this problem ad infinitum. We're both members of an NGO called the Justice Reform Project, where we do nothing but agitate about these issues. Mrs. Adekoya.
Thank you. The issue of court funding ties directly into the question of administration of the courts. I cannot see a law chambers or a law firm where the accounts officer or the accountant will pay any bill without the approval of the owner of the chambers or the senior partner. So I find it hard to understand how a chief registrar will be in charge of funding without the approval or the direction or the support of the chief judge. So if there are problems in funding, they are partners in crime. I think we need to look at the court administration system. The chief registrar wants to become a judge, so he's not going to want to offend his chief judge. And the chief judge knows he has the power to nominate him, and he's going to hold that over him or her. And therefore, the allocation of funding by a chief judge is the responsibility of the chief judge. Whether they spend the money on buying cars for the judges, or they spend the money on renovating magistrates' courts, or they spend the money on training for magistrates, or ICT technology, the buck stops on the table of the chief judge until we change the court administration system.
Mr. Ewilade, any comments? 1 minute.
Yeah, I don't have, I stand on the point just made by the learned senior advocate, Mrs. Funke Adekoya. Yes, I would respond on the issue of decentralization of the system later. Thank you.
Okay. As my Lord Justice Zana has said, the issue actually dovetails into what we had asked him to speak to specifically. And I'll give you a little background before I hand over to Justice Zana. Before we held the Justice Sector Summit, the NBA's Judiciary Committee had made certain recommendations to the National Assembly in the ongoing Constitution review process. And we sent in a bill, a comprehensive bill, I think it was a 32-page document, making several recommendations for amendments to the judicature provisions of the Constitution. And we made specific recommendations to address this concern about the administration of the courts and the need to professionalize the administration of the courts and insulate the heads of court from the day-to-day running. You know, I've heard really crazy stories like, oh, there's no diesel in the generator because the CJ is not around. You know, and you wonder, you know, how can you have a court running? The court is a very complex organization. How come there's no devolution of authority? How can you have a situation where everything is, you know, requires the signature of the CJ? There has to be an administrative system so that the judges can focus on writing judgments and listening to testimony rather than worrying about there's paper in the printer, etc. So our recommendation was that the constitutional structure should be changed, and that what we have now, that we should create a body. And as my Lord Justice Zana will tell you, he has accused us of cutting and pasting because we cut and paste from the UK, where the UK has what you call Her Majesty's Courts and Tribunals Service, which is a body that is independent of the executive and also independent, at least supposedly, and also independent of the judiciary, and reports to both the equivalent of the Attorney General and the equivalent of the CJ. So we put something like that in our recommendations. And Justice Zana, in fairness to him, and I'm really happy that we at least met each other on that point, he accepts the concept that there's a need to professionalize the administration of our courts. His concern was that the recommendation we made would drive a coach and horses through the independence of the judiciary, that we were handing over the key to the judiciary over to the executive, to the extent that the executive doesn't have the key already, or at least one of the keys. So my Lord Justice Anna, I think we're in agreement on that. And we've also said that, so what we want to understand now is, if we're not going to do it the way the NBA proposed, how do we go about professionalizing the administration of the judiciary?
Thank you very much, Tunde. To be honest, I want to be as fast as possible so that I keep to the time you've allocated to me. What you did in that bill was not even cut and paste. In highlighting in order to cut, you omitted safeguards that even them in England had and pasted without those safeguards. What you did was just arrested the judiciary, handcuffed it, and handed them over to governors and presidents to do as they please. And you cited the example of the US system and the Her Majesty's Court system and that of South Africa. All of them were better than what you proposed. But I'm glad we already agree that there was a mistake on that one. There was a mistake on that. And that is one of the achievements of the summit, I must say, that subsequently upon looking at it, there is consensus that, look, that one was overdone, was not even cut and paste. Now, the resolution that was arrived at, which I may read out fairly as captured, the resolution was that the administration of the courts be professionalized and separated from the administration of justice, thus ensuring that a crop of administrators with the requisite training and experience are engaged to manage the courts, whilst the judges focus on their core duty, which is the administration of justice. A lot is in the details, but where I agree is, yes, we need a professional setup to run our courts. Nothing scares me than vouchers and all this thing. I don't, it's not what I signed up for. To me, it's demeaning to start talking about Naira and Kobo. Well, my society and my creator has elevated me to the position of a judge. I have nothing against those who practice that profession, but I agree, we should professionalize. And there is a lot for us to do as judges that we don't need to waste our time on mundane administrative issues. So we are agreed on that. But, like I said, the devil is in the detail. There are two assumptions underlying that resolution. One is that there abounds in Nigeria a crop of trained and experienced professional judicial administrators. I don't know if anybody who knows of the school or university where they train these professional judicial administrators, but it is doable. Then the second underlying assumption is that these professional judicial administrators, when entrusted with the resources of the judiciary and power, unbridled power at that time, not answerable to anybody in the judiciary, that they will just sit down then and administer to the needs of judges and the courts professionally without any Nigerianness. These are the two underlying assumptions, and they need to be interrogated. Because we see administrators administering ministries of works, Ministry of Health, agencies of government. They are the professional administrators. Are they doing it the way we are saying they will do it if you give them the judiciary without any control? So that's the point. Now, you have asked me to talk today on the practicability of the summit's resolutions and ways of enhancing the implementation. I intend to do that. Each time I contemplate this issue of running the courts and the constitutional provisions, somehow in my maybe failed literary aspirations, I tend to think of a situation, a fictional situation where in 1999, when the Nigerian Constitution was sort of approved by the Armed Forces Ruling Council, that particular night when they had their last meeting before transiting to the civilians, I fantasized a situation where Justice Nikki Toby, of blessed memory, and Justice Uwais came out, and in the manner Benjamin Franklin was asked after the 1787 Constitutional Convention of the US, they were asked, "My lords, what have we got as a judiciary?" And them answering, "Independent judiciary, if you can keep it." We have provisions that, if we can use very well, can give us an independent judiciary. I know from my exposure, travels, and interaction with judges elsewhere and studying constitutional systems elsewhere, that there is a lot of good in the constitutional provision. It's only about whether we can keep it. And events are testimony as to whether we are keeping it or we are not. So, practicability of the summit's resolution, yes, they are practicable. We can do it. It's doable. However, how do we do it? Now, to my mind, there are certain things we should be very careful about. And once we are careful about them, then we can succeed. Remember, I am of the opinion that yes, we need to improve on what we have. That what we have now is unacceptable. That we need to improve on it. Good. So one is we have to design a system of court administration based on our experiences and knowledge of practices elsewhere. We can borrow, but we have to check whether this is going to work in Nigeria. What have been our experiences in the past? How have these things actually played out elsewhere? And we should not be afraid of original thinking in designing a system that achieves these goals. Two, particularly, we have to be very careful and ensure that whatever we come up with ensures, safeguards, and protects judicial independence. Otherwise, it is worse than running from frying pan to fire. It is just like drinking, what is that rat poison called? Otapiapia. We shouldn't be taking otapiapia just because we have running stomach. Sacrificing judicial independence, handing over the judiciary to the executive or appointees of the executive is like taking otapiapia. Or there's another one, or Gamalin 20, because you have running stomach. We shouldn't do that. Now, there's this point I want to make also. When we talk about judicial independence, let us be honest to ourselves in this country. If we are really determined to have an independent judiciary, we must have independent judges. And how do you ensure that? We must work towards and achieve a realistic compensation package for judges. Salary that they can take every month, plan, pay the fees of their children, live comfortably, and even save something and invest. That has to be part of their salary. Once we leave that, we give them only 20% of their needs as salary, and then 80% depends on some ad hoc allowances that depend on the whimsical approval of the head of court or whoever, or professional administrator or chief imam or pastor. It will not work. You are not having independent judges. Let the judge have a take-home pay that thereafter he doesn't need any further approval of Estacot or Rwanda trip in order to make ends meet. Once you have a system that is dependent on such approvals, ad hoc payments, then you don't have an independent judiciary because you don't have independent judges. And you will have letters, petitions, and all sorts of rigimo, jaga jaga. It will never end. That's my position. I've held that long ago, and I am seeing that every day I am being proven right. I have not deviated from that. So that is crucial in whatever we try to do. Then we should not also, in whatever system that we design, the control and power over that body should rest within the judiciary, not outside with the executive, not with the legislature. However, it should be diffused. It shouldn't be just the head of court alone that controls them. We can come up with mechanisms that diffuse that power and is not subject to abuse. I am not claiming that I have all the solutions, but I am sure that if we sit as bar and bench, there are brains that will come up and we can come up with something. Now, during the Justice Summit, I cautioned that, look, some of these proposal places where we are borrowing things from, that we interact with these judges, we know what is happening there. It is not what you think. Subsequently, events have proven me right, and some of the things I wanted to tell you and I couldn't are now out in the public domain. South Africa, one of the examples cited, recently appointed their Chief Justice. By the way, the three nominees that were considered for interview by the JSC were the number 2 man, their Deputy Chief Justice, the President of the Court of Appeal, and a Chief Judge of a state, the Judge President of Gauteng. I want that clip to be played. How these things that we were recommending play out in South Africa. Just listen to Justice Mandisa Maya, the then President of the Court of Appeal, now the Deputy Chief Justice, tell you about their experience under that system that we wanted to borrow. Please play that clip. Play the clip.
Do we have the recording? My Lord wants that clip played.
The recording. Oh,
yeah.
okay.
Sorry. So before the clip comes up, maybe in order, because I'm wrapping up with that one, as for the enhancement of the implementation of what we've agreed, of these measures, there is one key solution to it. We have to sit down and work it out sector-wide, bar and bench. We have the skills, the capacity, actually complementary. What I am trained and by experience happen to know may not be available to those at the bar. But so also what, through their practice and interactions, they have come to understand about the system cannot be known to me. Once we sit down sector-wide, go ahead and play it, and agree we can design a good system, and I don't think if we need
The
constitutional...
whole notion of establishing that national department was in addition to offering support, administrative support to the Chief Justice and the institution. It was to create institutional independence for the judiciary, which now has its hands tied behind its back because it has no control over its own budget and expenditure. You know, we've been walking this path, and JP Tlalize and all judges have been walking this path for a while now. The issue of resources is critical. And it's a big problem, not just for the judiciary, but for the taxpayer too, because judges not having a say at all on the tools that are needed for the execution of their work, judicial work, not just work, impedes their performance and sometimes even results in wasteful expenditure, such as being provided with expensive laptops which cost upwards of 34,000 rand because they come with useless accessories we'll never use. We are not consulted when those things are procured for us. We are provided with leather-bound diaries. I got one recently and I was asking who still uses a thick book diary in 2022? And other paraphernalia about which, again, we are not consulted. And instead, Chair, sacrifices are made in respect of critical support and tools of trade, such as something as important as court assessors who assist
Sorry, it's all right.
judges
Apparently,
in
because
criminal...
of the acoustics of the hall, we can't hear her. Let me just sum up what she's saying. They don't have control. The thing we are copying, those who, professional administrators and those in charge, when they want subscription for law report and law journals, there will be no money for that. Instead, they will be given leather diary, big diary that they have no use for. So this is the kind of things that happen when you take the control outside the hands of the judges. So all I'm saying is, let me just round up. Yes, we need to improve on this system. I don't see these crop of administrators that are so good, because I can look around and see government agencies and all these things. I don't see any better performance. However, that is not an excuse for us not to improve. I keep saying the other arms of government, whatever happens there, they are married to whoever they are married to. As far as the judiciary is concerned, judiciary is Caesar's wife. Therefore, we have no excuse. We have to improve and perform and deliver. Thank you very much.
Thank you so much, my lord. Thank you so much. Justice Enenche, I know there's one particular point I would like you to comment on. I know you probably have views on everything that my lord has said, but on the specific aspect of, we talk about professionalizing the judiciary, and where are we going to find these judicial administrators from? You spoke earlier about an experience you had in Dubai. Can you just share that experience with us?
Okay. There's a point we all are agreed on. And of course, that is, we want a better system. And a better system should be driven by people who are professional in outlook. That means both the head of court and the chief accounting officer who drives policy. And I shared with you earlier an experience I had when I visited the court of Dubai. And I had an interaction with the administrator of that court, who happens to be the equivalent of our chief registrar. And in the course of our interaction, I asked him if he was a lawyer. And he looked at me, with some surprise, wondering, like, why should a lawyer ever occupy this position? For him, the court should be run as a business. He should be responsible for the key indicators. How many cases come in? How many cases were resolved? How fast does it take from assignment of a case until that case is determined? So if, for instance, 10 cases are resolved this week, he wants to know why the next week only 5 cases were resolved. So to get to that, we need someone who has a business outlook. And that, for me, lies in the hands of the chief registrar, working with a very effective and efficient team. So it takes us to the point of appointing a chief registrar. We must know the quality and the caliber of people we want as chief registrars. If we have determined that, then we'll take the next step of determining where do we get them from and how do we get them. Can we get them from within the system? Good and fine if we're able to get them from within the system. But if we do not have people who meet those criteria within the system, then we should be able to look outside and bring in the best. But at the end of the day, we need people who can actually drive that process. So appointment to the office of the chief registrar should not simply be by succession, because the person started with the system and became a chief magistrate and became a director, and now is entitled to become the chief registrar. No, it's not a life position. It's not a chieftaincy title that you can inherit by birth or by position. I think it is a position that needs to be worked for. And in also determining that, the issue of the appointment of the chief registrar also comes into play. We must create what my Lord has referred to as a delicate balance, between bringing somebody from outside and also having an appointment that reflects the independence of the judiciary in spirit and in truth. You don't want to bring somebody who becomes a dictator because he's not accountable to anybody within the system. So you must have an appointment of somebody who reports within the system for the good of the system. But that person can come from anywhere, really.
Thank you so much. Thank you so much, Justice Eneche. Mrs. Adekoya, I think we spoke about this earlier, and one of the objectives of the Justice Sector Summit, as I said, and which I'm praying and hoping that we can take forward, is that we're now trying to address the challenges of the sector. The judiciary and the justice sector is too important for any one institution to address. And I think my Lord, Honorable Justice Zana, has acknowledged that and said that there are things that judges know, but there are also things that perhaps members of the bar know. There may be things that actually require consultants who are not even lawyers. So how do you think that the bar and the bench can best work together to achieve this objective of professionalizing the administration of justice?
Thank you. I think the best way going forward is for either at state level, bar bench forum, or at federal level, justice sector summit with federal judges and lawyers to sit and share experiences. When we started my law firm, I was the managing partner. And after 4 years of running the firm, dealing with budgets, appointments, KPIs, I was losing my clients. I didn't have time to go to court. So I'm not sure that being the chief registrar and running the court system can go together. I think we need to look outside that box. Unless whoever is going to be the chief registrar does not have an intention of wanting to go to the bench as a judge. But let the lawyers and the judges sit together, share their experiences. You find out that once you decide this is the structure you want, you can bring in management consultants to draw up the criteria, and you put out a tender.
Fantastic. Thank you very much. Mr. Wilade, we've run out of time. I was hoping that I could manage this session a lot better because we haven't touched on the third, and which is probably the biggest elephant in the room, which is the question of delay. But I can see that we're already at an hour and a half, which was when the session was supposed to end, and we haven't even dealt with Q&A. But Mrs. Adekoya, I know this is your issue. I'm going to guillotine you, even though our session coordinators have not yet rung the alarm bell. But I'm going to guillotine you. You were supposed to have 8 minutes. I'm going to reduce it to 5. But I think that Mr. Iwilade has actually teed up some of the issues, because I thought he was delving into your area when he was speaking about some of the inefficiencies and our penchant for dealing with technicalities rather than focusing on substantive issues. So in 5 minutes, please can you just address what you think are the major outcomes of the summit in relation to addressing the issues of delay and what you think we need to be doing going forward?
I think for me, one of the outcomes of the summit was that the lawyers felt the judges were the cause of delay. They wouldn't sit. They wouldn't inform lawyers that they are not sitting. They would adjourn matters. From the point of view of the judges felt the lawyers were the cause of delay. They were not prepared for their matters. They would come to court and ask for adjournments on flimsy excuses. What has come out of that is that before we can eliminate the inefficiencies in the system, we need to know what is causing those inefficiencies. And for this, I would score the summit 70%. Because after the summit, the Bar Association took up that portion of the summit and said, how are we going to find out what is causing these inefficiencies? And they came up with something called a court monitoring system. And I'm pleased to say that an NGO with which I am associated, the Justice Reform Project, is coordinating with the NBA to actually implement that court monitoring system by use of technology. I would have hoped that by this conference, we would have been in a position to announce the first set of results as to monitoring the courts. This is what we have discovered. X% of delays are caused by lawyers. X% of delays are caused by judges not sitting. But hopefully, by next year's conference, we'll be able to give a report. But for me, that was the major outtake of the summit, that we need to actually drill down and find out the extent to which lawyers are the cause of delay, because that's when we can remedy it, and the extent to which judges are the cause of delay, because then we can propose solutions.
Thank you very much, Mrs. Adekoya. The court monitoring project or court monitoring system developed by the NBA with the able support of the JRP is one of the greatest achievements, if I may say so, of the outgoing administration. And I'm proud to have been involved with that project from its inception. The app that Mrs. Adekoya speaks to is ready for deployment. But I think one of the things that we discussed, or that we have been discussing right from the time when this project got off the ground, is whether it is a project that requires the input or the approval or the cooperation of the judiciary. And one of the reasons why we have not yet launched, we have run a pilot scheme of the project in the Ikeja Judicial Division of the Lagos High Court. But one of the reasons why we have not launched it formally is because we would rather have the formal buy-in of the judiciary. And we think that this is something that should be, God helping us, a no-brainer. Because the NJC itself has a court monitoring scheme that it has been running for a while. And this court monitoring schemes, in our experience, we realize that it is capital and manpower intensive. So it is going to be a lot easier if the bar and the bench are working together to implement this scheme, the bar providing the manpower and the technology, the bench providing the support, because the data that this scheme will generate will be for the improvement of the justice sector as a whole. And so I'm going to seize this opportunity, even though at the Justice Sector Summit, we received the approval of the judiciary, but I'm going to seize this opportunity to commit the two judicial officers who are on this panel, my Lord Honorable Justice Zana and Justice Enenche, to recommit to support the implementation, the full implementation of the court monitoring scheme. My Lord Justice Zana, as a head of court, I know that once I have his sign-off, at least we know Borno State is taken care of. And he also sits on the NJC. So I know that once he signs off for Borno State, he will also ensure that he secures the sign-off for the courts right across the Federation. So I'll start with Justice Enenche.
If I could just speak on that briefly. You know, we already have an ongoing court monitoring system in the FCT, and I'll be happy to share with you when I return the results we have so far. But that is only with respect to criminal cases. It's ongoing as we speak. It's been ongoing for about 2 years, and it's also driven by an NGO. Exactly, past West Africa. Yeah, exactly. So we've been working with them, and they give us real, authentic data, you know, which is an indication as to how we perform, where the causes of delays are coming from. But like I said, that is mainly that addresses the criminal aspect. So probably we'll be happy to see you come in, you know, in the civil aspect. We'll be happy to have you.
Okay, let me make one thing clear first. I'm not representing NJC here. I am representing myself. And I'm probably even not representing the Chief Judge of Borno. I am probably that former president of the Students' Union in ABU, an activist. So, that said, I wonder if you are aware of the citizens' gavel that has been doing surveys of courts, and I think they call it the speed of justice or something like that. They are doing that with the sanction of the National Judicial Council, NJC, already. And they are given, in fact, they are even given court returns of cases by courts and all this. So I believe there is no big issue. If the point is made to NJC, NJC will cooperate, and then we'll have this thing rolled out nation. That is my expectation, because they're already doing that, and this one will be complementary, and there will be no problem.
Thank you so much, my Lord. Distinguished ladies and gentlemen, as I said, my time management skills have been sorely tested. The breadth of the issues that we needed to discuss were such that it has proven impossible to squeeze them into the time frame that we had available. I suspect there will be questions from the floor, but except Mr. Emunjeze, my boss, tells me I can spare time for 2 questions. Yes, I'm told I can spare time for 2 questions. So 2 questions from the floor. One from my very good brother, Mr. Rotimi Seriki, SAN, in the front.
Good afternoon, my lords, learned SANs, and my colleagues at the bar. My first question is directed to the Honorable Chief Judge of Borno State. And it has to do with the appointment process for judicial officers. My question is based on my experience as a former member of the Lagos State Judicial Service Commission. And by virtue of that position, I'm privy to the NJZ guidelines for recruitment of judges. And I am of the opinion, the humble opinion, that for us to attract the best hands to the bench, we need to review the criteria, especially as it relates to the number of judgments to be submitted by those advocates aspiring to go to the bench, and the number of judgments to be submitted by magistrates also, because as rightly pointed out by Mrs. Funke Adekoya, SAN, the process for becoming SAN in terms of cases submitted, cadres of court that those cases must cover, is the requirement for judges is a far cry. So if I believe that my question to the Honorable CJ, is it possible for the requirement of cases to be reviewed upwards? Because I believe that as it presently stands, it's not good enough to attract the best hands to the bench. And then the second aspect of is not a question as such, it's a comment. It's also based on my experience as a member of the Judicial Service Commission. In reality, there's no dichotomy between the CJ as the administrative head of the court and the chief registrar as the accounting officer. The reason is due to the fact that most times, those who emerge as chief registrars are usually magistrates who have aspiration to go to the High Court bench. So, and most times, the chief judge will not support a candidate for the position of chief registrar if the chief judge is not comfortable working with that person. So, it all boils down to a situation where, as rightly pointed out by Mrs. Adekoya, really, the chief judge is still in control of what happens. And if we are now talking about bringing in court administrator, I think it might be tidier to create a career path so that the person enters the system as maybe a fresh graduate and then gets promoted up to that point when he's capable. Because most times, when you bring in a chief magistrate to become a chief registrar, what administrative skills has that person acquired as a magistrate to qualify for the person to effectively administer the courts? Those are my questions.
Can I go? Yes. I think there is nothing to waste time on. I agree with you on both. Very simple. That's why I said we need to sit down and rework this system. There was wisdom. There is some element of wisdom in having the chief registrar and aspiring judge to be there. It's not only to the chief judge he has to be careful. He has to be careful also that the other judges are not offended, or at least have a good opinion of him, because they also have a role to play in his becoming the judge that he wants to be. But that said, we are agreed, as far as I'm concerned, that we need to rework this system and improve it. Look, things have expanded. The judiciary is larger. It's not the judiciary of those days. We have to now put on our thinking caps, sit together, use our experiences, design a system that will work for us. As to the requirement, I wonder your question whether you want the judgments increased or reduced. But whichever case, whatever the case, I think the point has been made that the appointment process needs to be looked at. That clip I played, although we couldn't hear Mandisa Maya, at least you could see transparency in play, whereby for the appointment of Chief Justice of South Africa, the interviews, they were being interviewed, and there were 3 candidates. The candidates were from a spectrum: the President Court of Appeal, the Chief Judge of a state, the number 2 man. And that interview, go to YouTube today and or Google Mandisa Maya, you will see it. So the transparency is even global. So there is a lot that needs to be improved. And I agree with you on both counts. Thank you.
Thank you so much. There was one further question, I believe. Yes, the gentleman in the 4th row. And that will be the last, well, I think it's the only question anyway. Please tell us your name.
My name is His Greatness Agadaigo from Asaba branch. Mine is just a contribution. I just wanted to add to the justice sector proposed reforms. And it is to the extent that, one, the CGN should no longer be the most senior justice of the Supreme Court, and also that the NJC too should be professionalized to the extent that there should be an independent chairman, independent of the CJN, and there should be no statutory members, so that they will be fully focused to deal with the issues that arise. And this should also apply to the Federal Judicial Service Commission. And also too, I wanted to propose that a judge, for the appointment of a judge to a superior court of record, that judge should be appointed by the NJC on the recommendation of the NEC of the Nigerian Bar Association. And finally, sir, I wanted to also recommend that this monitoring of the court system to ensure that judicial officers comply with judicial ethics and procedure.
And lawyers, not just judicial officers.
And lawyers
Yes.
should include ensuring that monitoring cameras are positioned in our courtrooms consistently. Thank you.
Thank you very much. I can assure you that all your suggestions are noted, and there's nothing that is off the table. The intention, and I'm so delighted that my Lord Honorable Justice Zana has confirmed that the intention is that the bar and the bench, going forward, will work together to overhaul the system, because there's an acknowledgement that the system is not working optimally and that there's a lot of improvement that needs to be made. So with that, having overstayed our welcome, it's left for me to thank our panelists, Honorable Justice Zana, CJ of Borno State. Thank you so much, sir. Honorable Justice Enenche, Justice of the FCT High Court, Mrs. Funke Adekoya, SAN, and Mr. Iwilade. Thank you so much. And thank you to you, our audience. Thank you for your patience. And I hope you enjoyed the session as much as we did. Thank you.
Thank you very much, Mr. Moderator, Dr. Tunde Ajibade, SAN. Very interesting session indeed. Ladies and gentlemen, please give them a round of applause. Like I said, it is a very important session, and you have seen from the extensive discussions that it is very important. Please, before our panelists leave, we have some gifts for you from the TCCP. Please hold on. We are going to take a group photograph and we'll present some gifts. May I call on the chairman of the Continuing Legal Education Committee of the MBA Lagos branch, the host branch, to please present these gifts to our panelists and the moderators, and they will take a group photograph before we leave. Thank you very much.
On behalf of the TCCP and the LOC, we present this to you, sir. Thank you for coming. We're really grateful for giving up your time. My Lord, on behalf of the TCCP and the LOC, we present this to you for giving up your time. Thank you very much, sir. On behalf of the TCCP and the LOC, we present this to you now. Thank you for your time. On behalf of the TCCP and the LOC, we present this to you, sir. Thank you for your time. Leonard Silk, on behalf of the TCCP and the LOC, who present this to you, sir. Thank you very much, sir. Thanks for your time.
Thank you so much.
Group photograph, please. Mr. Awolabi, please join them. Group photograph, please. Thank you. Mr. Aderemi, please come and join us for the group photograph. Thank you very much, ladies and gentlemen. My Lord Justice Zana, we thank you very much for the insightful conversations. Mrs. Funke Adekoya, we thank you. Dr. Tunde Ajibade, I can assure you that Dr. Ajibade will continue being at the forefront of judicial reforms in Nigeria. Thank you very much for your time.